Gentleman from Texas, Mr. Weber.
Thank you, sir. All right, here we go. I'm going to read from the President's executive order. I just can't hardly be quiet anymore if I can get my iPad here working. In his order, February 28, 2017, Section 1, Policy, it is in the national interest to ensure that the nation's navigable waters are kept free from pollution while at the same time promoting economic growth, minimizing regulatory uncertainty, which was referred to by the gentlelady from Oregon. We'll talk about that in a minute. And showing due regard for the roles of Congress and the states under the Constitution. Mr. Chairman, I'd like permission, unanimous consent to read into the record the 10th Amendment. Have it placed in the record, rather.
Without objection.
Thank you. Mr. Chilton, you said you've been farming, or you've been ranching, your family has for 127 years. Is that true?
That's exactly true, yes.
Are you glad that your great-grandparents, your grandparents, and your parents took care of the property and you were able to do the same kind of ranching?
I am.
They did a good job, didn't they?
They really did a good job, and we really have an excellent ranch with wonderful grasses, and we take care of our land.
It's in your vested interest, isn't it?
It is.
You said earlier in your testimony that you had to get a permit and you had to pay a lot of good money to an environmental attorney. Is there any other kind of money, Mr. Chilton, than good money?
All money is good.
Absolutely. And you're tired of giving it to a lawyer, right?
I hate giving it to lawyers. I hate listening to lawyers.
I don't blame you at all. Mr. Kopocis, I'm going to come to you. Is the Supreme Court ever wrong?
The Supreme Court is the law of the land. There are.
That's not what I asked. Does the Brown v. Board of Education, Plessy v. Ferguson, or Dred Scott cases ring a bell with you, where they actually reverse themselves?
Yes, yes.
Okay, so we do know that they are wrong.
They do reverse themselves from time to time.
Okay, so they do make mistakes. All right. So in your discussion, in your exchange with the gentlelady from Oregon, she made the comment that it created regulatory uncertainty. But I will tell you that the regulatory uncertainty was created long before the case got to the Supreme Court. It was created by an overreach of the federal government. The 10th Amendment, the reason I want it read into the record, is because you just got through with Dana Rohrabacher saying that the 2015 rule gave the states the authority. I would tell you that is so patently false on its face. Read your Constitution. The federal government is delineated with what their responsibilities and what their powers are by the founders of this country. All others are given to the states and the people respectively, period, end of sentence. That's just exactly the way it is. When the federal government starts feeling like it has to dole out powers to the states, something is wrong, terribly wrong with this country. Let me continue. That's my op-ed for the minute, okay? I hope I wasn't too forceful to you. If I was, tough.
Well, perhaps,
I'm going to go to
perhaps I should have said that they basically just took the federal government out of it.
Okay.
It wasn't an affirmative.
Hey, if we can get you on record for wanting to take the federal government out of the WOTUS, we're all for that. Are you on record saying you want to take the federal government out of it?
I don't believe the federal government.
Okay, Mr. Hopper, I'm going to come to you. In President Trump's executive order, February 28, 17, I just read, he directs EPA and the Army Corps to consider the Scalia opinion in the Rapanos case in its revisions to WOTUS. I got two questions, really. I've got about a minute left. What is the difference between Justice Scalia's approach and Justice Kennedy's, and why does it make more sense to follow Justice Scalia's? Mr. Hopper?
First to the second question, as I outlined in my law review article, it's required by law to rely on the plurality decision authored by Justice Scalia than it is the Kennedy approach under the Supreme Court's Marks decision, which says when you have a split decision, you look at those justices who agreed in the final judgment, which would be the four in the Scalia plurality, and Justice Kennedy. You never look to the dissent. All these other courts that have held that the Kennedy test is controlling have relied on the dissent. This is
isn't that interesting?
Yeah, it is, and that's contrary to the express decision by the Supreme Court in Marks. Your other question was?
What was the difference between the approach and Kennedy?
Yeah, the difference is significant. Mr. Kopocis is right that there's no question that the Scalia plurality is going to be narrower. And that's why it falls under the Marks decision. When you have two competing, concurring opinions, you look to see whether one is a subset of the other. And the Scalia plurality decision is a subset of the larger interpretation of Justice Kennedy.
Good point.
The major difference, though, however, is that under the Scalia plurality, it's fairly definite in that it describes relatively permanent tributaries and abutting wetlands that are indistinguishable. However, through the significant nexus test, it can only be applied on a case-by-case basis, and that's where the lack of clarity comes. And the WOTUS rule that was published in 2015 continues to rely on this case-by-case analysis, which gives nobody any security or certainty. Judge Kelly in the Eighth Circuit said, interestingly enough, the Clean Water Act is the only law I know of where you have to hire an expert to determine if it even applies to you.
Well,
Not to
thank you,
mention
Mr.
an
Hopper.
attorney.
Thank you for your indulgence, Mr. Chairman.